If we do have some people in the room, I want to say thank you very much for joining us at our fireside chat today. As always, we're going to have our moderator, James Chapea, asking some questions. He asks smarter questions than I do. He understands the topics a little bit more deeply. And that's why the panelists like talking to him better, to be honest. Why I'm so excited about this topic today, because we want to see clean tech companies in Canada expand internationally. Our market is not big enough for you to really make Canada a prosperous country, really build that sustainable economy that we want to have as an engine for Canadian economic growth. And also, you can't have the impact that you want to have on our climate challenges if you only sell to Canadian customers. So that's why it's so important to start looking internationally early in the development of your venture as you start selling. And it might be scary. It's going to be maybe more challenging than operating your business and selling to somebody in your backyard. But that's the purpose of these couple of talks that we've had, is that there are folks who can help you. There are folks who've helped many other people. There are folks who know how to do this well. And we're lucky enough that they've popped in here today to share some of their expertise and be available to answer your questions on how you too can structure to enter the US properly so that it's a win for your company and not a distraction. And the other thing I wanted to mention is we've always got great things going on at Foresight. So I'll mention our next fireside chat towards the end of the hour, but I do want to point out, if you are going to be around Vancouver, Calgary, or Toronto on the 29th, we have our demo day that you can pop into in any of those. And I'm sure Astrid will be providing a link for that towards the end of the day. And also next Monday, we're going to open up our recruitment for our winter cohorts. So if you know of any clean tech startups who need a little bit of support, could use a little bit of guidance, want to have some frameworks and some tools and some great mentors to work with, that'll all be open on Monday. I'm giving you a little sneak peek there. Maybe we just want to roll through the agenda quickly, and then we can move on to the better and greater things. Before we get talking too much further, I do want to take a minute to acknowledge the land on which we operate. For myself, it's the traditional, ancestral, and unceded territories of the Tsleil-Waututh, Squamish, and Musqueam nations. I encourage you to know the status of the treaties and the First Nations and Métis people on which lands you might be operating from today. Next slide, please. As always, I've almost stolen my allotted introduction time, though James will, I think, let the panelists introduce themselves as well. So I'll move on quickly. We'll have that panel. We'll hopefully have a lot of questions from you, because again, what we're trying to do is add value to you, our wonderful audience. And we'll have a couple minutes at the end where I'll remind you of those things I just mentioned. Next slide, please. As you all know, if you're here, you probably know a little bit about Foresight, but our goal is to get Canada to be the first G7 country to reach net zero. This is an ambitious goal because, newsflash, everybody, we're in 7th place. We're back of the pack, so we have a long way to go there. But I think if we do this, we will develop the technologies that will help other countries also move towards net zero quickly. And we will do that thing I mentioned earlier, which is build a prosperous engine for the Canadian economy that is sustainable. Next slide, please. How we're going to do this thing? Well, we accelerate companies. We bring wonderful subject matter experts like we have on our panel today to give advice to move companies more quickly through their commercialization journey, all the way up to scaling up to be wonderful unicorns. And we also work with industry. We bring them to the table through the innovation challenges. Ultimately, what we want to do is help people with capital attraction, export development, and we want to build that ecosystem. I think on the last slide, it talked a little bit about what we call the Helix 5. Academia, industry, government, innovators, and investors. We want all of them talking to each other and breaking down the silos so that they can support and move more quickly. Next slide. We've had the opportunity to work with some fantastic founders, over 870 different ventures we've supported. That's resulted in over $1.54 billion of economic impact. Very, very excited about the results to date, and really more excited about what we can do in the next 8 years. It's taken 8 years to get there. We know we're going to far exceed that with the help of everybody in this room. Next slide. All right, I'm going to turn it over to James to introduce our panelists.
Oh, good day, everyone. Thank you, Stephen. Actually, what I'm going to do is I'm going to let each of the panelists give you a little bit more of their background. I know them, but I think that we always do a better job of talking about ourselves. The topic matter today is we obviously have to look for markets that are larger than where we are. And as Canadians, we do think globally. So one of the closest places we tend to do is we look at the States. The problem is a lot of companies end up getting their heads handed to them when they go across border. And that actually isn't just Canadians going south. We all remember what Target did. So it is when you're working cross border, you need to learn some of the things that you actually don't know. They are two separate companies. So let me turn this over. Kristal, will you please introduce yourself?
Happy to. Thanks, James. I'm Kristal Allen. As you see on the slide, I'm a partner with the law firm MLT Aikins, based here in Calgary. My practice is a technology practice, which has a additional focus on privacy and data protection issues. Happy to be here today.
Thank you. Dean.
Yeah, thanks, James. Dean Radomsky. I'm a Canadian tax partner here with EY in Calgary, and I've been working in tax for over 30 years, I guess. And did a lot of work on international tax clients, and then more recently, a lot of work with CCPCs looking to go into the US.
Thanks, Dean. Last but not least, Reis.
Yes, thanks a lot. So I'm Reis Pagtakhan. I'm a partner of Kristal's at MLT Aikins, but I'm out in the Winnipeg office. I practice in the area of immigration law and have been doing so since the late 20th century. That's how old I am. Totally enjoy the craft. Have a lot of fun doing it. Looking so much forward to being part of this panel. Dean, just want to say thanks for setting it up in terms of the case study that we're doing. I think we're going to have a great time, James.
Thanks. And actually, I love the case study approach. It lends itself. Now, for all in the audience, this is part two. Part one, we covered off a lot of the tax aspects of and structural, how you set up companies. What we're going to do is deal with something a little bit different today. Today, we're going to look at, now that you're in the US or there's some things that you need to consider. When you're going cross-border, there are things that we don't tend to think about, but we have to. Things about how do you move your employees? How do you operate? Something as simple as where can you sign agreements? Can you sign them when you're in the US, or do you have to be here? Where do I house data? What are the legal implications? Are there tax implications? And when we were setting this up, unfortunately, I was driving and I missed the call. And so I just found out that I got picked to set up the company, and I'm now the one that has got James Co. So lesson learned, don't miss your meetings. So what we're going to look at is things like transfer pricing, providing service in the US, and so forth, as you see. So now what we want to do is we're going to turn it over and set the stage for this. So can we have the next slide? So what is going to happen? My company, James Co. I am a Canadian controlled private corporation. Really important because most of the companies that we deal with early stage are, but that can change, and that can be a challenge. I actually have my business as a SaaS-based business. I have developed IP in Canada, and I want to start taking my business to the US. And how do I go about doing this? Where do I get my sales? How do I deal with that? Do I deal with in Canada? Can I just provide that to the States, or so forth? Let's move forward. So I'm going to turn this over to our experts, and they're going to provide me advice as to how I should be doing this. So I'm a Canadian, as we see, I'm a Canadian company and operating in Canada, and I have a US client. Reis, what terms and conditions should I be looking at with respect to software licensing agreements? Is it easier to have the company in Canada? How do I go to the US? What is your advice to me?
Okay, so James, I'm going to be talking about the people aspect of things. I'll let Kristal talk about products. I'll let Dean talk about profit. But on the software licensing agreement, if you want to have your people, your staff, your contractors enter the United States to install software, to upgrade software, or if it's equipment because you have hardware or other equipment to repair that, maintain that, install that, then you need to have specific provisions in your contract that allows for after-sales service or warranty work. And the important thing that you need to do is say that either my employees are doing it, or if you have a third-party contractor who does it, name that a third party will do it. Because if you don't have that in the contract, or you don't have, let's say, an after-sales service contract that you enter into at the exact same time as the sales contract or the licensing agreement, then your people can't go down to the States. And if your people can't go down to the States, then you might be a bit hooped, because then you're looking for US folks to do it, or to train US folks to do it. So you want to make sure that's in the contract at the outset, because if it's not at the outset, then you have a lot of challenges getting your people down stateside.
Okay. Kristal, licensing. What else do I need to think about?
Yeah, so there are several things to think about with respect to data when you're structuring a software license agreement, which is probably not surprising to hear. And sort of what is relevant and important in terms of the provisions that you would include in a software license depends to some degree on the type of data that your software is sort of handling or being used to process. So for all types of data, whether we're talking about personal data or just kind of commercially sensitive data, there are some sort of common things that your contract should address. It should address things like, where the data that the software is processing or being used to sort of handle will actually be sort of stored or located, how that data that the software is processing can be used and processed, and if there are any limitations to that, and how that data can be retrieved or returned to the client in the event that the agreement comes to an end, or there is some other request for a return of all or a part of that data. In addition, those provisions should really clearly address any particular security standards or safeguards that James Co. will be using in providing services through its software. If we're talking about personal data, there are some additional considerations that your contract should address. So that should address things like privacy standards that James Co. will comply with. So what is the applicable law in that circumstance? Are there additional privacy standards beyond that applicable law that James Co. would apply to how it's sort of handling and treating and processing that data? And finally, I think an important thing to note that often isn't that well addressed in software license agreements is that if we are dealing with personal data, it is particularly important to ensure that that contract talks about how data breaches or data incidents will be sort of reported, investigated, and handled, and what kind of collaboration would occur between James Co. and the client in that circumstance.
Okay, I'm going to dig just a little bit deeper, because obviously we're seeing things in the press happening. Is there going to be obligations for me to release information related to breaches? How do I deal with that? And are there regulations associated with how I have to govern and store that data that I need to be aware of?
So there are, and there's a bit of a patchwork that exists depending on the jurisdictions in which you're operating. So in Canada, in the EU, and in certain jurisdictions in the US, there are actual legislative requirements regarding the reporting of data incidents or breaches and how those incidents and breaches sort of need to be mitigated or handled. So, and typically those legislative requirements specify a time period within which particular types of data incidents, particularly those that have a measurable impact on the individuals whose data has been exposed, need to be reported back to the regulator. So in some cases, that is kind of an as soon as possible time frame. In other circumstances, that's within, say, 72 hours. So it's typically requiring, and what we're seeing globally really is a movement towards being a bit more prescriptive in terms of what is required with respect to both identifying, containing, and reporting data incidents, just given the magnitude of activity that is happening, kind of from a cybersecurity and frankly, hacking and ransomware perspective.
Yeah. By the way, two quick things. For those that missed our first Fireside chat, it is available online. It was recorded, so you can take a look at it. This one is being recorded as well. So everybody that you can turn in, because obviously there's a ton of information that's going to be here. Just for the audience, if you have questions, please put them in the Q&A, and our panelists can actually operate and answer them real time to you. As well as we can just address some of them, so it's easier for us to deal with it there. Now, Dean, so I've got this set up. I'm now dealing with this US client, and I'm making money. Where am I going to have to report? Where do I get taxed on this? What do I have to do from a financial perspective? And what are things, by the way, for the audience, what we're trying to do is make sure that they know that they need to ask you guys questions. And a lot of times we don't even know what the questions are. So here's a question for you. Where do I report this? Where am I getting taxed?
Yeah, no, fair. That's always the question, and how much? I like this starting point for I'll just take a step back, and then we'll kind of go forward. Is that this is sort of an example of doing business with the US. So in other words, you're not walking across the border as much. You're not having people across the border. You're not doing stuff in the US. You've got all your data, you've got all your development, everything's in Canada. And essentially you're providing this software or whatever it's going to be to your US client and essentially getting paid for it. So this is an example of doing business with, and then the next couple of examples is going to change it, where we're going to start doing business in, and you'll see how simpler this is from the other ones. But before I kind of even keep going is that the tail never wags the dog. Is make sure you follow your business process and stay in your lane, and don't really change your business process to try and get rid of a tax issue, or try and get rid of to avoid filing a return or something. That's when things fall off the rail. So follow your business plan, and then we'll figure it out from there. Is what I like to tell the clients. But anyway, so this is, like I said, it's relatively simple. You've got the US client paying, James Co. for the use of the software. James Co. will be taxable on that. And under the Canada-US treaty, given that James Co. is a Canadian corporation resident in Canada and taxable in Canada, normally there shouldn't be any withholding tax on those payments withheld by the US client. So it should be relatively clean, and that's because we have a treaty with the US, and we have treaty for like tax treaties with many countries around the world, like everybody else has. And that's essentially to stop double taxation and to really narrow down as to when do you have a taxus nexus in my country. And so at this point, the treaty tells us that we're okay with withholding tax, and it's quite simple from a Canadian point of view. However, over and over again through this presentation, I'm going to keep saying you got to talk to the US folks. And on this issue here, on this sort of little starting point, the federal US tax is very, very different from the state and local taxes in the US. They are two separate things. Many states don't even acknowledge we have a treaty. So you're not going to be able to carve yourself out of certain things in the states that you would have federally. Where the difference here in Canada, mostly everything's pretty much tied with respect to our federal legislation of income tax and our provincial legislation most of the time. So now when you're going down and you're doing this kind of stuff, the questions that I would ask is, do I have any state tax obligations if that US client is in Alabama or Michigan, or because there's 28 states that tax digital products. And so we got to understand that. There's also might be possible filings or sales and use taxes in some of those jurisdictions. So always it's asking what is the state tax issues, and that's where really we like to focus on. And then lastly, the only thing you may have from a federal perspective here on a US side is in certain circumstances, you may need to file what's called a federal protection, like a US federal tax return, to basically take the treaty position that you are a resident of Canada and you're not subject to the taxation in the US. And so that's always a consideration as well. So there's really two questions: is what's happening to me in the state taxes where we're at, and do I need to file this treaty protection return?
Okay, thanks. And I had heard it's at one point there's something like 1,500 different taxing jurisdictions in the US, which is like, okay, I'm never going to figure that out. Can we move to the next slide? Because we're going to change this and make it a little bit more complicated now. And so now I'm getting into the place where I actually have US clients. I'm looking at what throws me offside as far as a change in my activity. Like, what is it that I do, and how do, if I'm doing this, I'm now establishing a permanent, what they'd call a permanent establishment in the US, and what does that mean for me from a people perspective, obviously a data perspective, and a taxing perspective? Reis.
Well, from the people perspective, in terms of if you need to actually have your folks service the stuff, install the stuff, or your folks doing the sale, it doesn't change as long as the contract for the Canadian-made software, it has to be Canadian-made software. You can't sell US-made software in the US with your US staff unless you get special, visas for that, because it's US-made stuff. As long as the contract's with a Canadian company. If you start routing it through a US company, and here we're looking at a branch office, so it's probably still a Canadian company, then we're fine. But the minute you start doing the contract with a US company, then the Americans might give you some trouble with easily transferring your people over without having to go through a little bit more of an immigration process, which we can talk about a little bit later on. But the simplest way to do it is, if you can still sell your product from your Canadian company to your US company, you still have those provisions in the contracts, your folks can go down and they can sell, they can do the install, they can do the maintenance, they can do any of that kind of stuff.
Okay, would I be making any of those, my employees, taxable in the US by sending them down there? Do I have to second them, or how do I get them across the border to do things? Do they need a visa? What is it? What can they do or not do?
Well, I'll let Dean answer the question about, if they're going to be taxable. But what typically happens if you're a salesperson of a Canadian-made product or software, or you're doing after-sales service work or maintenance work or repair work or on software or hardware or equipment, then you can enter the United States as what's called a business visitor. So you show up, you show them the contract, you indicate to them exactly what you're doing. It has to line up with the services in the contract, and it has to be valid during the period of the contract. So you can't have like a 1-year service contract and come on year 5. Then you're normally allowed to enter as a business visitor to do that for whatever period of time you need to do that work. Whether you have to pay the IRS, I'll let Dean answer that fun question.
Okay, let's just deal with like an operational one. First, though, when I'm doing this and I'm collecting data, whether it's associated with the contract or I'm actually processing it or the software is doing something, does it, Kristal, does it really matter where that is going to take place? Do I need to be cognizant of a physical presence as far as data centers or so forth when I'm doing this operation, and how that data is being stored?
So I think the short answer, James, is that on whether it matters is yes and no. What really, the devil is in the details here from a data perspective. And what I mean by that is what is happening in each of the locations is sort of what drives the analysis here. So we still, in this example, have a Canadian entity that is entering into an agreement with a US client. So presumably the contracting party there is still the Canadian entity. The software product that is being used here presumably is still the property of and being offered by that Canadian entity. But what's coming into play here is that we now have a physical location of some sort of operation of James Co. or some element of its operation in the US. So the question from a data perspective becomes, what is happening at that establishment in the US? And does what's happening there involve some sort of processing activity regarding data that is kind of collected from this client? So if, for example, that US establishment involves, for example, a data center or a data warehouse, which would be a fairly common scenario, then what is presumably happening is that some of the data, if not all of the data that is collected via that software from the US client, is being housed, at least in part, in the US, perhaps processed, at least in part, in the US. And then we have to think about what the impact of that activity is on the client. So what the impact of that would be is really driven by what does that do in terms of the legislative framework that applies to how that data is actually being used, handled, and processed, and how it can be. So in this case, if that data warehouse or data center results in the data processing activity by James Co. actually happening in the US and being sort of solely conducted in the US, then that in some senses actually simplifies things for the US client, because now there is a more sort of local to the client occurrence of the data processing, which would mean that the bulk of that processing activity would be subject to the more local US legislation, which the US client may be more comfortable with, may prefer the application of in any event. So it can cause a simplification. On the other hand, if we still have some activity happening in Canada with respect to the data and some in the US, then we get into those questions of sort of which legislation applies, which should apply, what standard does the client want applicable to the handling of their data, and does the contract between the two parties adequately consider and reflect that? It becomes a complicated issue at a high level, but we can break it down in pieces and simplify it very well through contract and through transparency between James Co. and the client as to what's happening and what's expected.
So is that done through, like, how do you evidence it? Do you have to, what type of documentation is actually done to make sure you can demonstrate what's going on? And what happens if, you know, obviously a lot of this isn't probably not going to get processed on my own. I'll probably be subcontracting out through Amazon or something else where some of that's taking place. Does that cause even furthermore issues, or does it simplify it that I'm not actually doing something?
Well, I mean, it can cause issues, but the issues are all surmountable, right? So the key thing to be mindful of, regardless of sort of where the activity is occurring and which jurisdictions and which parties may be involved in the activity, is ensuring that there is appropriate, for lack of a better way of saying it, paper between those parties. The crux of the issue here is ensuring that the client at all times has an understanding of where their data is going to be sort of stored, where it's going to be used, where it will be processed, and who may be involved in that processing, at least at a high level, and reflecting that in the contracts that exist between those parties, trying to set kind of a common standard in terms of how data is used and processed in the manner in which it is acceptable amongst those parties, and kind of laying a groundwork so that the client has a high level of transparency regarding what is happening with the data that it is making available to James Co. and potentially its subcontractors, and also ensuring that it is able to determine where that data may be located so that it can ensure that it's comfortable with how that data may be handled in that location, and also able to get that data back and retrieve it in the event that it needs to do so.
So obviously this is going to be really important to my operations, because I'm a small co dealing with a large, obviously, probably a larger co in the US. And so my client's going to want to be able to know what the heck is actually going on. So
yeah, they are. And if you're dealing with a large company client, for example, it is fairly common for a client of that sort of size and sophistication to actually say to you, James Co., the sort of smaller SaaS service provider, that they would actually like you to ensure that you are complying with and will be able to comply with a set of data protection measures that they use within their own organization. And they may ask you to either ensure that those data protection measures are reflected in your own contract with kind of equivalent provisions, or they may ask you to actually append to your contract a sort of schedule or rider that includes those provisions that they are used to using, because their interest is going to be ensuring that how you are handling data is consistent with how they would handle data and be obligated to handle data within their own organization, so that they're outsourcing something to you, engaging you to do something. And because they remain accountable for the data they've collected, they want to ensure that you're handling it in a way that is consistent with how they would handle it.
Okay. Dean, what do I got to be worried about?
Well, just staying, so permanent establishment is just, our first example of doing business in the US. And so usually, if you're going to do business in the US, you're going to do it either as a branch or a corporation. A branch is sadly, it's sometimes you fall into having a branch by accident in the US. And simple things like having a salesperson that's, traveling around the US, concluding contracts on behalf of James Co. in the US and selling a whole bunch of work for you, which is great, but that can now give you a taxable nexus, which is what really a permanent establishment is in the US. Other things, like it says here, the branch office, place of management, other things that can happen too to cause you to have a branch is providing services for, they're in the treaty again between Canada and the US. There's some specific clauses in there that deal with, how long you can provide a service for until you end up having a permanent establishment in the US. So there's lots of things to sort of keep in mind as you start sort of playing around and trying to do business in the US. And sometimes you don't want to trigger a branch, and we can do it a little differently, like we'll talk about in the next couple slides. But so if you end up with a branch, James Co. then has a US corporate tax return to file essentially in the US, and all your income that's attributable to the activity of that permanent establishment in the US is taxable in the US. Now, from just a pure tax standpoint, you also have CanCo, James Canadian Co., that's also going to include that income in its tax return in Canada. But given what the treaty tells us, it means that then James Canada Co. gets a tax credit for essentially the taxes that they pay in the US. So provided, let's say that you've got an Alberta company, because that's where I am in Alberta, and we got a 23% tax rate in Alberta, and you've got a permanent establishment in the States that has a combined 21% rate. So you'll be taxed at 23%, but you'll also get a credit for the 21% that you paid to the US. So hence, you shouldn't get any double tax. But it does get messy if you don't catch it in time that you figured out that you have a branch or not. And so it's nice to get the calls when we're thinking about going down to the States. It's messy to get the calls. We've been down there for 2 years. Somebody gave us a phone call from a state and asked us why we were in their state and why we were selling stuff. And then all of a sudden you determine that you had a branch for the last 2 years, which that can really trigger is going back to what Reis sort of passed back to me on was you have individuals down in the US now, and it's very quickly you can have an individual in the US that's going to be subject to taxation in the US solely by having the costs of that salary deductible deducted against the branch income. So so then you're stuck into payroll, and you're stuck into preparing W-2s for all the employees and getting them to and helping them file their U.S. tax returns. So getting in front of all this stuff with respect to making sure that you don't fall into a branch in the U.S. is important. I would say 8 times out of 10, when we're structuring in, a branch is not our preferred approach. Largely, I mean, the lawyers are on the call. It's largely probably a lot of legal stuff as well. You don't want to have, James Co. taking on the lawsuits in the U.S. So anyway, just the branch is mostly an accident that happens is what I'm saying. So that's what we have to watch it, and that's why I tossed it in here.
Okay, yeah, that's a major oops. Let's move to the next one. Okay, so premises establishment.
I think one more, James.
Oh,
the next one, actually. There you go.
Okay.
Yeah, we're forming the U.S. now. There.
So we're now in the U.S. So now I'm forming this U.S. co. Some of the things that I'm going to actually address, I'm going to step back a little bit on this as well, because Reis, I'm going to want to know, like, what are my immigration options about how do I get people into the U.S.? What should I be looking at? Obviously, Dean just told me I'm going to have I could find myself in a real tax problem and my employees not happy with me. Let's address that about how do I do this? Do I move people down there? Do I hire in the US? Do I second people? What is it that I need to think about?
So once you set up a company in the US, then you open up a few more immigration options. So let's assume for the moment that James Co. Canada owns and controls James Co. US Inc. If that's the case, then you can take employees that are your executive level, managerial level, employees that are called specialized knowledge, or employees that are called essential, and you can effectively transfer them to your US corporation to do those kind of jobs. Now, there's specific definitions of what all of those things are, and not everyone that has the title of manager fits the managerial definition for immigration. But you can take some of your very key people and you can send them down to the US to do a whole bunch of stuff. They can either go down to manage the company internally, where they're not client facing at all. They could do client facing things. They could work, sometimes they don't even have to work at your office. They could be off-site all the time working. There's certain definitions for that. There's certain criteria that needs to be made by that. But the investment in the US, the structure is really important. If when you're expanding into the US, it's not a wholly owned subsidiary or a majority owned subsidiary, but you've brought on a US partner, or you brought on a Canadian partner because you need a Canadian partner to help you expand into the US. If the proper immigration relationship isn't created between the companies, then you might have some restrictions. So you really want to get ahead of understanding who you need in the US. And again, we don't want the tail to wag the dog, but if getting your people there is very important, then we need to understand, can we make a couple of tweaks to a prospective structure to make sure your folks can come over? One other thing that I should mention just generally, James, and not that many people know about this, but there is also a specific immigration provision that allows Canadians to work in the US and get immediate lawful permanent residency, or what they call green cards at the border, if they are Indigenous Canadians who meet a certain level of what the Americans call blood quantum. So you have to have 50% or more of Indigenous ancestry. And then you can, show up at the border with your treaty card, with all of the documents that show your blood quantum. You get classified as what the Americans call an American Indian, and you can just work in any capacity in the US. So it doesn't even have to be executive or managerial or specialized knowledge. You can do anything in the US as if you just immigrated there. So for companies that have Indigenous employees or Indigenous run companies, that's something that you have to take a look at. Now, the definition is very specific and you have to have specific stuff to prove that, but that actually gives a lot more labor market flexibility working in the US. Doesn't, help you necessarily with the tax question because, I'll leave that again to Dean, but it does allow the work in the US.
Okay. Kristal, is this going to change anything with respect to data or like things like IP data and so forth, my corporate intelligence?
Yeah, so it can have an impact. And again, I think a similar question arises here as arose with respect to the permanent establishment question in the previous slides. And that is sort of what role is the subsidiary organization actually going to have? So is it now going to, for example, become the contracting party with the US client so that the contract with the US client actually references James Co. US Inc. as the licensor, the service provider, etc.? Is that subsidiary going to be performing data processing activity kind of on behalf of James Co., but located in the US? Is that US subsidiary going to, for example, be responsible for running and operating a data center? The activities of the subsidiary are relevant here and kind of drive a bit of the analysis. So if, for example, that James Co. US Inc. is now going to be the contracting party with the US client and will be responsible for the delivery of the software, for support of the software, for conduct of data processing activities through that software, and that's all happening in the US, that can frankly kind of simplify things for the US client because it really gives that localization component that we may be looking for. But what it does potentially create is a little bit of complication between the related James Co. entities. And that complication is really most pressingly in relation to the software itself. So for example, I think we had talked about in the fact scenario that James Co. Canada was sort of the developer and owner of the relevant software in this case. If they set up a US subsidiary and that US subsidiary is now sort of licensing or making available that software to a client through a direct contract relationship between James Co. US Inc. and the US client, we now need to make sure that at some point we have some documentation evidencing some sort of license or assignment or what have you regarding the ownership of that software from James Co. Canada to James Co. US Inc. in order to enable that relationship between James Co. US Inc. and the US client to occur. So there are a variety of considerations here, both on the IP side and on the data side. Having a US entity more directly involved with the US client can simplify things on the data side, but it can complicate things on the IP side.
So you really want to get that relationship documented between the two sides. That you can't just assume something is actually going on. It actually, you need to get that done. Dean, like now, so I'm setting up a U.S. operation. Now you've got, you indicated there's 28 states that are going to tax differently. It doesn't really matter where I set up this U.S. co, and from how do I manage now? I've got these two companies, so how do I manage where the income flows and those things? And the last question I'm going to ask you is, does it matter what kind of U.S. co I establish? Like in Canada, you don't have a heck of a lot of options, but there are definitive options in the US, B Corps and so forth. Should I be looking at those different alternatives? And I know that that's like probably a 10-hour discussion, so we'll just try and see what
yeah, no, you see in the very last little point there, it says LLC bad and it's underlined. The quirky thing with the US tax is that they have these concepts of substance over form, but also they have these concepts of disregarded entities. And so a LLC in the US can be a disregarded entity for US tax purposes, which means it's just like I own the assets myself, and I just have this thing for legal liability, and that's it. So just to put it to the extreme is that there's you can have an individual that would own an LLC that's disregarded. 100% of that income would come onto their T1 or their 1040 in the US. Okay, so that's a flow-through entity. It can be a flow-through entity. It can also be checked to be not a flow-through entity, but it can be a flow-through entity. But when you layer that on top Canadian rules, where we're very legal form driven and a box is a box, the net of it is that you wouldn't get foreign tax credits in Canada, or it'd be very challenging to get foreign tax credits in Canada. And so you're going to dump yourself into double taxation. So having a LLC in the US as the first company underneath Canada is not good. Of course, as you go forward and you can put LLCs, you can talk to your US legal counsel and they can put LLCs underneath whatever they think is the right thing to do. But that's why I specifically put the Inc. in the name that for the US co.
Okay.
Now the next step sort of goes to a lot more deeper on the secondments and everything like that. But this just gives us the box. We've got now a US corporation that's going to have a US GL, US dollars, and it's going to file its own US tax returns and state tax returns in the US. And then we can touch base about a lot of the stuff that Kristal brought up, which is really about that value prop as well as what who owns it, and we can chat about that on the last slide.
Okay. So does it matter where this company is going to get established in the US? Because I'm now just saying I'm operating just in Washington and I wasn't planning on doing anything. Should I be looking at other alternatives?
That's really a legal question, to tell you honestly, James. From a tax standpoint, it's going to be the same. It's going to be the same from a tax standpoint, as long as it's an Inc. And but you'll need your guidance from the U.S. legal counsel on that, because sometimes there's it's easy. Like a lot of people like Delaware law for if you're going to go list something or and if you want to work with a specific lawyer, he may only be able to form an entity in a specific place too. So there's lots of stuff like that, but that's really a legal question.
Okay, let's move on. Just given how much time we've got.
Yeah.
So obviously now the U.S. is providing services, okay? And we're going to deal with the next 2 slides. But so I've got Canadian employees going to the U.S. They're doing work there. What I'm kind of wondering about is, can we actually, Kristal, send personal data across this border, and what do we have to do in that regard?
Yeah, so in this context, I think what we're most concerned about with is if we're moving employees from James Co Canada to James Co US, that the movement of those employees is going to involve kind of perhaps a transfer of their data from the Canadian entity to the US entity to kind of manage that employment relationship, et cetera. In that circumstance, I think that the short answer is that there is really little to no legislative prohibition on making that sort of data transfer between the two countries. Canadian privacy law in general does not prohibit the movement of personal data from Canada into the US, for example, or into other foreign jurisdictions. But that doesn't mean that it happens just sort of completely freely with no other considerations involved. So generally speaking, across Canada, both in terms of specific content of some of our Canadian privacy law, as well as interpretations of Canadian privacy law that various privacy commissioners have taken, kind of supports a couple of things happening in the event that we are moving that data out of Canada and into the US for some sort of purpose. One of those things is that there is an expectation that some sort of notification of the fact that that information will be sort of transferred out of Canada, used outside of Canada, is provided to the individuals to whom it relates. So those employees would need to have some form of notification that their personal data may be moved, transferred, or sort of used outside of Canada. And what form that notification needs to take kind of depends upon what James Co. Canada's privacy practices have been with respect to their employees to date. So does their privacy policy, for example, consider the fact that that type of movement of data may occur? If it doesn't, then we may have to find another method of notifying employees that that sort of movement of data may be occurring and the purpose behind that. In addition to that, if an organization is moving data outside of Canada, and that data relates to Canadian residents, or people who were residents at the time that information was collected, there is still an expectation that the organization who is receiving the data outside of Canada is going to be held to appropriate sort of data protection and privacy standards that are consistent with what would be expected by that Canadian data subject if that information was still in Canada. So with that in mind, between these two entities, there may be an interest in ensuring that there are consistent privacy policies, consistent privacy procedures, consistent data protection sort of documentation that exists between the two entities, so that there is some assurance to employees that regardless of whether their data is in Canada or the US, as long as James Co. Family of companies, if you will, or related entities are handling it, that it will be handled consistently and in accordance with a data standard that aligns with what would have been required in Canada.
Okay, Kristal, so do you help companies actually make sure that they've got those documented policies and procedures in place?
We do. This is I'll just say, this is a fairly common scenario, James, when there's expansion outside of Canada into another jurisdiction. There's often movement of employees. There's often movement of data independently of movement of employees. And what we try to help organizations do is figure out sort of what their data map is, if you will. So what are the data flows between their related entities? And do they have documentation in place to support those data flows, to help keep them compliant and to help them be able to accurately sort of track and assess where data is, so that they're able to respond to queries, complaints, incidents, etc.
Okay, Reis, so I've got my US subsidiary. So I'm the CEO. I'm going to go to the US. I'm going to be dealing with my US client. I'm bringing my sales guys down with me. I hit the border. What do I need to do? What are the issues I need to be before I actually get there? Is there something that I need to be concerned with as I'm crossing that border to deal with my clients in the US?
So if you're just going down for a meeting, negotiating a contract, waving the flag essentially, the likely scenario is you can just say, this is what I'm going to be going down for. Maybe you have a bit of an agenda for the meeting. Maybe you have a letter that indicates that you'll be coming across. That's sometimes a little bit better to act as talking points, so to speak, and you can do so as a visitor. But if your folks are going down to actually work, so someone's going to be selling products, being there for months on end, maybe years. You're going to go down as a CEO and you're going to relocate there, or you're going to be down there a lot more often. And you're going to direct employees and you're going to direct the management of the company, those types of things. Then you're really looking at a more formal immigration status in the United States, or what they call a non-immigrant status. And there are 4 ways to do it that are the easiest ways for Canadians. I mean, the Americans have a lot of ways to get into the US, but the 4 easy ways to do it are this. So number 1, if you are an American Indian born in Canada, if you are an Indigenous Canadian that meets that definition, that's the best and the most flexible way to do it. And you can apply for that at the border. You got to have all your paperwork, but you could apply for that at the border and you can get in at that time. So that's the best option. The next 2 options sort of are tied for second. There's one that's called TN status, where you're working as a professional. A CEO doesn't qualify as a professional because you have to be working in the specific profession. But if you're on that list of professions under the free trade agreement with the United States, it's a finite list. That's a great tool to use. Again, you can apply right at the border. You can get up to 3 years entry to the United States for that, and you can go back and forth for that period of time. The next status, L status, is just as good, but a little bit more expensive. It allows people that are, again, this is the executive, the manager, the specialized knowledge employee that we spoke about before. They can also apply right at the border, and they can get in on that trip. So that does give you flexibility. It gives you 3 years at a time, but there is a cap on that. So if you're a specialized knowledge employee, you only get up to 5 years. If you're executive or manager, you get up to 7. If you just started the company, you might only get 1 because they want to make sure the company's, the real McCoy. And then so that's sort of those two, the TN and the L status are tied for second. And then the last one that you would want to go to is what's called E status. It takes a little bit longer because you got to file the application in advance. You got to go for an interview in advance before you get the visa. So that can add weeks or months to the process, depending on the situation. And you only really use that if the employee is essential and not executive, managerial, or specialized knowledge, or doesn't meet that definition because they're a new hire. Because the L status for those other occupations require 1 year of work in the company in Canada or abroad, like if you have an operation somewhere else, that counts too, before entering the US. So those are the 4 ways that I would look at it. But if you're going down for a meeting, that's probably okay. But if you're actually going to be working in the United States for extended periods of time, or on multiple trips, so you're going to go down every couple of months or every couple of weeks, then you probably are looking at more formal status. But James, one thing, let's say you don't get yourself prepared and you show up at the border and the officer says, well, I think you need L status, or I think you need E status, or I think you need a TN or whatever. And then they'll throw whatever letter of the alphabet that they have, because the Americans have statuses that start from A and they go to, I think, B. And you have no idea what they're saying. You will likely have the opportunity to what's called withdraw your application from entry to the United States. So what you just say is you say, look, let me go back, get everything organized before I come back here. And then there's no prejudice to you. Okay. If you stand there and make I've set up a company, my tax dollars pay your salary, I demand to get into the United States, James, you're going to get an attitude adjustment by the officer. And that attitude adjustment may result in a multi-year ban from the United States of America. It's just like, when you talk to the cop and they pull you over for speeding and you scream and yell at them, you're going to get the ticket. This one is you're going to get banned from the US. So don't attract the attitude adjustment.
Okay. In the interest of time, because we only got a couple minutes left, Dean, there's a question for you about WBBE and she. I have no clue what that is. Maybe you could just type an answer. But what I'm really interested in is, so Reis, you gave me the answer. You're going to get an attitude adjustment, but if I get this wrong, it's probably going to cost me a lot of money. Dean, thoughts?
Well, getting it wrong would be not using your US Inc. You set up the US Inc. for a purpose, and that's to do the business in the US. So essentially, if you're going to send people down from Canada to go and work on projects down there, they're going to work through the US entity. So the US entity's got the contract with the client, and you second your employees down to US Inc. from Canada. Then you'll get them taxable in the US, which you're just going to have to deal with and have a payroll in the US. Then they'll get some foreign tax credits on their personal tax returns, and they'll be kept whole eventually. But essentially, where it can mess up is that, no, I'm just going to actually just send the employees straight down to the US client's office to start working without really doing the formalities of doing the secondment down to the US the US Inc. and then getting them into the client from there.
Okay. One really last quick question, because I know this is a real issue. If I'm the CEO, I'm now down in the US, and I actually start doing exactly what you're saying, is I start operating and I sign contracts down there. I'm obviously now going to be operating in there. What happens if I actually get DocuSign or something else that's documented? Is it going to be form over substance, or is it thoughts?
It's where you sign it, I think, really, at the end of the day. And then whether you're sitting in Hawaii and you're signing it on the beach, I'm not sure. Honestly, James, it can get to pretty granular, but
okay.
But to answer the question really is if the CEO is an officer of the US Inc. as well, and he's signing contracts on behalf of US Inc., then it kind of makes sense. I mean, I don't know really how it affects Reis's, positions on that kind of stuff, but if he's in Canada and he's signing a whole bunch of sale contracts for clients in the US, and he's signing them for US Inc. in Canada, then we can have a little bit of an issue of maybe causing a permanent establishment of US Inc. into Canada. But let me get to the end of it. When you net out a bunch of the costs and all that stuff that happens, it may not be a big deal, or it may be a really big deal.
Okay. Thank you. It's been fantastic. I hope for the audience, they realize that some of the questions that they need to ask, hopefully you can provide us your contact information, because the whole point of this is that we need to come talk to you, because I think having that conversation up front is going to save us potentially a real, well, that was just an oops, and now I'm a permanent taxpayer in the US for the next 7 years. Awesome. That's great. Thank you very much. Stephen, do you want to just wrap her up? And thank you so much for everybody joining us.
Yeah, thank you to all the panelists for the wonderful information. As the slide states, there's the deadline for application to the Kickstart launch and Earth Tech programs we'll be running in winter. Also, do stay tuned in. We will be having another Fireside Chat in December, on December 13th. It's going to be on capital markets, so talking about what's going on there. We'll have some great experts, including some of our friends from KPMG, dropping into that one, so don't miss out. And as James said earlier, this recording, the recording of the first session, and recording of all our Fireside Chats are available on our YouTube channel. So go check out there for some extra learning and reading, or to revisit some of these topics, because there's a lot of detailed information that happens. So if it went by too quickly, feel free to slow it down and watch it like 0.75 speed, so you get that molasses effect on everybody going slowly. Don't do that chipmunk speed. Do the molasses one. Okay, thanks everybody. This was a lot of fun. I learned something new, and have a great day.
Take care. Thanks, everyone.
You.
Thanks.